Welcome to today's video. Our topic today is for conditions for imposing liabilities. What is the concept of liability? The concept of liability begins with it occupies a pivotal position, serving as the linchpin that connects the legal rights, duties, and accountability within a legal framework. So, liability in its essence encapsulates the notion of legal responsibility, where every individuals and entities are held answerable for their actions or omissions that they have purview under the law. Now, what is liability? Liability comes out that someone breaks the law, and the law sets out rights and responsibilities for individuals, and it grants legal rights to one person and places obligations on another. And people who should not violate the legal rights of other, and if someone does violates these rights, then they are considered to have done something wrong, and which leads them to liability. Liability is also defined by some legal experts, like Sir John Salmond has defined liability as the necessary conditions between the wrongdoer and the remedy for the wrong. In simpler terms, it links the between someone who did something wrong and the solution to make it a right one. And according to Austin, it prefers the term as imputability instead of liability. He says that certain actions, omissions, or acts, along with their consequences, are attributed to the people who did or didn't do them, and in other words, it's about holding people responsible for their actions or inactions. According to Mark B., he defined liability as a situation when the person has the duty to fulfill, whether the duty is their main responsibility or secondary or enforcing one. It's about having a job to do. What are the types of liability? The types of liability can be like the civil liability and the criminal liability. For civil liability, it refers to the legal responsibility one person or entity may have towards another in matters related to non-criminal issues. It arises from violations of civil laws or regulations, typically involving disputes between individuals or entities, other over issues such as the contracts, property rights, or personal injury or family matters. When someone is found civil liable, then he or she may have to require to compensate the injured party through the remedies like monetary damages or a specific performance. Civil liability cases are usually initiated by private individuals or organizations seeking the compensation or dissolution of a dispute. Now, criminal liability. Criminal liability pertains to legal responsibility or individual or entity bears for action who violates the criminal laws and regulations established by the government. Crimes are generally offenses against the society as a whole, and the government represented by prosecutors initiates criminal proceedings, and it goes on like this. If someone is found criminally liable, they may face penalties such as the fines, imprisonment, probation, or other punitive measures. And the purpose of criminal liability, is to punish the wrongdoer from violating that are intended to protect public safety and order. For there is a very distinction between criminal liability and civil liability, which according to John Austen's perspective, states that an offense that is pursued at the discretion of the injured party or other representatives is considered a civil injury. On the other hand, offenses pursued by the sovereign or its subordinates are crime. All absolute obligations are enforced through criminal means. Now, liability can be further classified into two categories, that is, penal liability and remedial liability. Penal liability can be explained as it is based on the principle of ubi jus ibi remedium, which means that there is a right and there must be a remedy. So when the law establishes a duty, it ensures that there is a means to enforce it, and in most cases the law prescribes a remedy for breaching a duty, or these remedies is enforced by the legal system. For penal liability, the legal principle or the maxim that use that actus non facietorium nissimens citria, that means that the act alone does not account to guilt and it must be accompanied by the guilty mind. So this is the fundamental to understand the penal liability. The two essential conditions for imposing a penal liability is the actus reus and the mens rea. Actus reus means an act is considered a voluntary physical movement caused by the will or desire of the person. It involves bodily movement resulting from the person's intention, provided the body part involved is in the normal condition. In simpler terms, it is the willed bodily action. Some legal scholars like Holmes have narrowed it down to a voluntary muscular contraction. Now, for mens rea means the guilty mind and represents the mental element required to establish criminal liability. It delves into the mental attitude of the person accused in the crime and various mental states that can be included in mens rea, such as the intention, recklessness, malice, negligence, and heedlessness or rashness, all these words accompanied by mens rea. The concept of mens rea has evolved over the time, and in many cases it is being replaced by legal standards set by the law. So additionally, different classes of offenses may have varying requirements regarding to mens rea. So liability is the central to legal framework, and these individuals can be held liable for their actions, leading to remedies or penalties depending on the nature of their violation. This is a conclusion, and here it ends our presentation.